There's such a lack of understanding, I think, in that legal entity and that interplay between liability. There's a whole education piece. I often think that before being able to be appointed a director, you should have to run a particular course to understand your obligations as a director and what that means in running. It would just not get rid of these issues, but it would certainly help people understand further, and would maybe allow businesses to do business in a way that it's certainly different to now.
Cathro Partners presents The Cut, a podcast about all things insolvency. Hi, my name's Andrew Blundell, Principal at Cathro Partners. Welcome to today's episode of The Cut. Today's guest is Anna Taylor, Principal at Results Legal. Welcome, Anna.
Thanks, Andrew. Thanks for having me.
Yes, we've been trying to get you on for a little while now. I know the crew up at Results are very interested to listen to this episode when it finally goes to air, and I'm sure you'll have a lot of fanboys and girls talking about how good you were today once it's up there. So thanks again for coming.
No, of course. Thanks for having me. Looking forward to it.
Yes, it's always good fun. You and I have known each other for a while now. I know you've been practicing in your space for the last 15 years or so. Why don't you tell me a bit about you and obviously what you do?
Yeah, so obviously I'm a lawyer. I practice in commercial litigation with a mixture of bits and pieces of insolvency and debt recovery. And I focus, I guess, on that trade credit space. So I'm creditor friendly, as I'd like to say.
Creditor friendly. That's a good way to be when you're advocating for your clients, particularly when they're in circumstances of difficulty. In terms of like what you're seeing that's coming across your desk today, tell me a little bit about that. What are your clients experiencing? What are you noticing? And what do you think is going to happen for the next 6 to 12 months?
I think it's a really interesting time at the moment. If you ask anyone in trade credit, they'll tell you they're super busy, whether you're an insurer, a broker, a lawyer, or, a supplier. There's a lot happening in this space, and I think that's because of what we're seeing in the economy generally and what's happening in the market. I suppose across my desk and those within my team and the firm, we're seeing a mixture of different things. We've certainly seen an increase in the high volume activity, coming through our debt recovery, through to our paralegals. There's been an increase of disputes, which, is not surprising given what's happening again in the economy. There's been a spout of preferences coming through, which, we all love and, have strong feelings with respect to. A lot of PPS type work, pre and post insolvency type work, and a lot of equitable priority disputes happening because I suppose with the shift in the property market and then how that interplays with, I guess, the economy and what we're seeing generally with respect to corporate Australia, there's been many an equity priority dispute flowing through that we've seen happen sort of in the last little while.
Sure. I mean, not dissimilar to insolvency practitioners, obviously, when things are tough or have been becoming tough, the volume of work that we're engaged with obviously rises, and the interaction with different legal firms and stakeholders obviously increases as well. Just in terms of the trade credit side of things and just your advocacy as a lawyer on behalf of your clients, you're one of the people that I've come across in this space that's very, very proactive. You're always on the front foot. You're getting in early, making sure you're communicating when required, and obviously advocating in your client's best interests. There's a lot of work that goes in behind the scenes, particularly I'm assuming when you take on a client or you're doing a review of their trade credit practices. Tell me a little bit about that. What are you looking for? What are you hoping to put in place so that, I guess, if for whatever reason one of your clients gets to a point where they're involved in some sort of insolvency event, you're best placed to get the best result for them?
Yeah, look, good question. I suppose I'm always sort of telling my clients it's all about that setting up from success position at the beginning. It's that risk mitigation piece that actually starts at the moment in which you engage with that customer.
Yeah.
And it sits around that contractual framework. It's setting up your business for success, making sure that you have the appropriate contract that gives you rights and different things to do in the event or worst case scenario event. I suppose as a litigator, it's really great always to have tools at your disposal, and they start right at that beginning with that contract. And then it's running a proactive credit management process where you understand the customer, you understand who they are, you understand their habits, you understand their behaviour, and then you mitigate that risk by, I guess, engaging with them in a certain way.
Yeah.
And that's well before you even have to sort of, I guess, call upon your lawyer to help.
Sure. There's a lot of, obviously, things that come across my desk, particularly in the personal property security space, where it's been around for a long time now. There's a lot of large trading entities that still don't have the fundamentals in place in terms of correct registrations, in terms of making sure that their terms and conditions allow them to take charges over particular assets where possible. It still surprises me every day, and I always encourage my team to make sure that they work through the process to confirm whether a registration is valid or not when someone like myself gets involved. I know you're very heavily involved in thinking that through with the clients that you've taken on and continue to take on. What's your, if you could distill it into I guess, a couple of minute, here's the things that I'm looking for, here's the things that would and should be at the top of clients' minds when thinking about shoring up their position. Well, what are those things?
Yeah, look, I think it comes back to firstly making sure that you have the contract in place that'll give you the right to take the security in the first place. So I'm always surprised too the number of clients that come to me with documents that aren't worth the paper that they're written on, or go about putting registrations on the PPSR but don't actually have the entitlement or the right, or think that they've got the ability to register, say, an all-PAP, and there actually isn't a proper personal property charging clause drafted into that security agreement. So I think first and foremost, it's making sure that you have your contracts reviewed, making sure you've got the rights to do certain things. And then assessing your customer base and, if you're going to be registering on the PPSR, well, what does that do to your commercial relationship? Is it that you're registering simply by virtue of an ROT because of the, say, goods that you supply? Or is it that you want to actually take an all-PAP over, your personal charge with respect to the property? So assessing that and then, making a decision, whether it be by credit limit or whether it be by risk of that particular customer as to whether you actually put that registration on in the first place. So that's, I guess, that risk mitigation around personal property. There's also things that you can be doing with looking at guarantees, whether they be by way of an individual or a cross-company type guarantee, but looking at your options. I think the number one rule is, and what I say to my clients is, you should always be making sure that you are in the best position possible. And if you have problems with your position, you should always look to improve it. Because the reality is when there is an event of worst case scenario or something happens or the company's placed into liquidation or there's an appointment of a VA, you want to actually have strategies to implement and you want to have levers to pull to try and get some sort of recovery.
Yeah, and it's a balance between that commerciality aspect and obviously trying to protect your client's interest to the best of your ability in that circumstance. And that's something that I know a lot of the trade credits managers that I speak to, and you obviously speak to too, are constantly having to juggle. Trade credit insurance is a big thing, particularly for some of these larger businesses. Some of them self-insure, some of them have obviously facilities provided by companies that are based overseas and they're now obviously reconsidering their position given the change in the marketplace and the number of claims that are coming through. So I was speaking to one the other day that you and I both know, and they're obviously engaging 3, 4, 5 other new employees to keep up with the demand from the claims side of things. And there's obviously a lot of toing and froing on whether the paperwork's been completed properly by both the insured and their customer in relation to whether the facility will respond to some sort of claim. And there's a fair bit of angst happening in that space that is obviously going to continue through the next period, given where we are economically.
Yeah, I think you'd be surprised, like the number of disputes, for example, that cross my desk in a week, when the actual dispute itself is something so simple around, a contractual piece being incorrect, or the dispute is as to who the parties would, what entity the parties were dealing with. It's actually, a lot of the disputes are actually really, really simple. That could be, improved or made redundant if that sort of front end setup of that business transaction was done properly.
Yeah.
So I think always the message is that, the basics aren't to be overlooked.
Yeah.
And it's often the basics that you find that you're litigating on as to, simple things around, does that, do these terms apply, or do these terms apply, or who's the overarching contract, or is that registration valid, or, was there a right to register that, all those types of things. They're really quite basic.
Yeah.
Arguments to be having, but could be overcome with better practices, I think.
Yeah.
And it's not just the little guys, it's, big businesses that seem to make those mistakes. And
I've got one at the moment. So I'm looking at a very large financier who I don't think's registered their PIMSI correctly over a large transport fleet, and that's hundreds of thousands of dollars that's potentially at stake, that if they'd obviously registered correctly, that they'd have an entitlement to recover those assets and pay down their debt to the value of whatever they could recoup. So you're right, it is something that constantly needs to be looked at. And the way that legislation changes and case law changes in respect to the Personal Property Securities Register, it's something that credit teams should be thinking about, at least on a ongoing, probably a yearly basis, just reviewing where they sit in terms of their agreements and whether it's fit for purpose. And I know there's been a few submissions and things that have come and gone over the years in relation to changes, and there was one that I know you contributed to recently, particularly around the PPS. So all of those things are really important for clients to consider and obviously engage with a advisor that's on the front foot and making sure that they're across those changes so that they can adapt their policies and terms accordingly. Just stepping back to the advocacy piece, I know, as I flagged earlier, you're one of the people that always seems to be on the front foot. You're engaging, particularly when there's some problem with a client, making sure that you're writing to, if it's an insolvency practitioner, that practitioner as soon as you're aware of an appointment, putting them on notice to provide documents, and particularly if there's security registrations, and working your way through that process. That's not something that a lot of lawyers seem to do, and it's obviously a testament to the way that you go about things. Tell me your thought process when you receive a call from your client who says, hey, Andrew's been appointed liquidator over one of our customers. Can we look at our documents? Can we get our house in order? How does that all work from your perspective?
Yeah, look, and I suppose I've had an increase in this type of thing happening in the recent months with what's looking at with the insolvency numbers.
Yeah.
I think first and foremost, you hit the nail on the head. It's about firstly having a look at, well, where do you sit first? So before you do anything, you need to have a look at, okay, well, there's been an appointment. What am I? Am I a secured creditor? Am I an unsecured creditor?
Yep.
Because depending on where you sit on that will depend, I guess, the next actions in which you take. So you have a look, you understand where you sit. You look, okay, do I have registrations? Do I have a security agreement in place? Do I have a debt owing? Do I know who I was dealing with? Do I have stock? Where is the stock? You have to run through all these questions internally and really understand your position, because, again, then that, I guess, takes into account the next steps in which you take. Once you've established and identified who you are, so you might be secured, you might have some trucks on the way with stock in it, or you might have, goods held in a warehouse or something like that. You understand where you're at. You then, very quickly need to be getting in front of that practitioner. You need to be notifying them of who you are. You need to be notifying them of what you've got. You need to be notifying them of your contractual arrangement, your registrations, and, if it is a scenario where you're a business that supply goods or, perhaps even people with respect to a temporary hire or, placements, things like that, you need to be notifying them of all of those things and calling for a stock take. So they know who you are. and they're aware of your existence.
Yep.
And then if there is anything that is yours, that you can be, looking to make a claim over that really quickly. Yeah. So I guess it's a time crucial type thing, and I guess the quicker you are on it, the more of a reaction you will get immediately, and the response, and then it's allows you to understand where you sit. And once you've sort of done that and you've notified them and you're aware, everything that then flows from there is a matter of just, I guess, making sure that your position's protected, and that your rights are reserved. So, it's as simple as writing them a letter or engaging an email or picking up the phone and saying, here I am, this is what I've got, this is what I'm owed, and I need you to take me seriously and don't do anything with anything that's mine unless I let you.
Yeah.
And, time and time again, I do see clients come to me and it's, there's been a couple of weeks past.
Yeah.
So practically what can happen there is that, stock may be dispersed, or it might suddenly disappear from sight, or what you might have thought was the position as to your exposure might have increased because you haven't been able to stop a chain of events that would follow because you weren't I guess proactive and on the front foot.
Yeah. No, it's one of those things, and there's different practitioners that approach it differently. Like, I know that it's always front of mind for me, particularly because of the work that I do in the trade credit space as well. It's one of those areas that I think there's a lot of scope for better communication between practitioner and creditor, and working together to achieve an outcome, knowing all of the other stakeholders that are involved in an appointment process. So, yeah, it's about making sure you put them on notice, give some details around what stock's there, conduct a stock take, allow access for the particular creditor, if they've got a valid registration, to come in and inspect stock, not necessarily take it, but come to some sort of commercial arrangement about, if you're trading on a business, how you account to the secured creditor going forward. And it's that communication piece that, particularly from a creditor's point of view, if they have security interest over goods they've supplied, that you need to be on the front foot for. And yeah, as you said, a lot of people wait 2, 3, 4 weeks, and circumstances generally change, particularly in if it's a voluntary administration trading appointment. We might have sold a business in that time. We might have disposed of stock that was potentially subject to a PPS, that there's a collective requirement for both the practitioner and the creditor to be on top of, so that everyone knows where they stand as soon as possible, so you can make decisions on where to go.
Yeah, and I think too, there's been a real shift, certainly in that pre and post appointment piece, I think, in the last 6 to 12 months because of what's happening in the market. And I think if you're sitting sort of idle and you're waiting a couple of weeks' time for things to happen, there can be things that happen that aren't the best for the company or for the creditors. For example, the appointment of the actual practitioner might be something you need to look at closely and quickly.
Yeah.
And I mean, that's certainly something over the last even 12 to 18 months, something my team and I have been really scrutinising, because, as the insolvencies have increased, we've seen a lot of activity that's been questionable, and or we've seen appointments that, need to be closely looked at, like as to, how was that particular practitioner put in and whose interests are they actually acting for. And if you're a creditor that's, owed close to, say, $1 million and you've got stock on hand and, you want to understand the position, yet, there's been an appointment of a practitioner who's been put in, albeit independently, but for the sake of, say, a secured creditor, that can have a really big, impact on the outcome of that particular appointment. So I think being proactive and really asking questions and challenging not so much the appointment, but just making sure that, you're across how it all is from your own side of things, and then also the appointment side of things, is something that I've been encouraging everybody to be looking at.
Yeah, it's interesting. There's obviously, as an insolvency practitioner, you've got to be making decisions that have wide-ranging impacts, generally pretty quickly, and sometimes with incomplete information. But you've got obligations in terms of writing to secured creditors and engaging with them as soon as possible, so you can kind of get an understanding of the lay of the land very quickly. And I know there are circumstances, particularly from some of the trade credit guys that I speak to, where that engagement has happened from the creditor side of things, but the insolvency practitioner is not necessarily responding in a timely manner to allow them to obviously understand their own position and to make commercial decisions as to how to proceed going forward. So by getting on the front foot and advocating like you do, that puts them in a position where they're forced to do their job effectively, and they shouldn't have to be, but that's sometimes the nature of those types of appointments. So, I mean, in terms of the behavioural piece, can you give me some examples of what you've seen? And I don't want you to name specifics or anything, because it's more an educational piece for the profession, in my view, as to how things have been approached and how you have moved to protect your clients' interest when you don't think that they're being approached in the way that they should be.
Yeah, I guess, I mean, the approach always is the same in the first instance, to understand, like I said, internally what's going on, and then to make contact and to state the position. I guess what I have seen, and more recently I've had a couple of matters that I've been involved in where, the conduct of the practitioner has been probably somewhat surprising in that the delay in which it's taken to respond to certain things, or the failure to just not respond at all when there's stock sitting there that needs to be considered, or for example, and this is just a really simple example, but last week I was involved in something for one of my clients. One of their customers had appointed a small business restructuring practitioner. Yeah. And my client, is a really proactive creditor. And, they register all PAPs, for example. Yep. So for whatever reason, they had been caught up in the proposal that was, being put forward, yet my client was secured. Yep. And so my client had to take the time and effort to, argue that point with the practitioner, and was sort of getting nowhere. So they, referred it on and got me involved. When I spoke with the practitioner as to the, understanding, well, my client's secured, have we considered this? The response in which I got from this particular person was that, the director told us that this particular client of mine was unsecured, therefore we, included them in the proposal. Yeah. Now, the time that was wasted for that, the cost that would have been incurred, coming out of, that appointment, and then the cost for my client having to go through all of that, when a simple grantor search would have given the answer. Yeah. I was blown away. So it's things like that, I think, from, a creditor perspective that you do see time and time again. I mean, there was something that I was involved in a couple of months ago, whereby the engaging or the communication with the practitioner had started around November of last year. And, back and forth, there were periods where we were getting no response. There were periods where we'd get half responses, things like that. And it wasn't until, a couple of weeks ago, my client was paid out as to the proceeds of their stock. And it had taken so long to get to that point. But in other instances, I completely understand, there are things that need to be looked at and considered, when you're looking at, say, the position of, a secured creditor and how that matches up, or, I completely understand there are things that do take time. Yeah. But I suppose there are, though, too many times where you are really left questioning what's, sort of going on and why steps are being taken. And it's not just that post-appointment piece. I think I mentioned at the beginning around an increase in preference activity. Yes. That's certainly been something that we've seen sort of heating up in the last few weeks. But I've got a matter at the moment that I'm involved in whereby this litigation's been on foot since the start of the year. And it's plain on the face of it that the proceedings should never have been commenced, in my view, of course, as against my client, because my client's secured. Yeah. And so I've, gotten involved in the last 2 months, and I've been pressing the point, well, show me how my client's not secured. Yeah. And it's very plain on the face of it that there is no position here, again, in my view,
yes.
That my client secure, that, you know, there's any sort of claim against my client. Yet the time and the cost and the delay that has got to this point, had it all been properly considered at the beginning, and perhaps, you know, respectfully, the liquidator read his own reports where he had acknowledged this, you know, years ago, that, you know, we wouldn't even be in this spot. So, you know, there are just things that happen, and you've got to wonder why these actions are being taken, or, you know, why the costs are being incurred, because ultimately it's a cost to the creditors. It's, you know, it's you know, funds that aren't being distributed, you know, when claims or, you know, matters are being run, particularly in that preference space, that, you know, that have no merit. I mean, it's that preference piece is something that I'm quite passionate about, and
you and everyone else in the credit industry.
You know, and I mean, you and I, we wrote those submissions, you know, for the Senate inquiry. What was it, February last year, around some sort of activity of practitioners, you know, engaging in preference matters. You know, when, you know, there is no merit to the claim that's being made, and it all just appears to be action run on a speculative basis, and, you know, everybody's a winner apart from the creditors. You know, those types of activities. You know, and so I guess those are the types of things that creditors you know, have to deal with. And, you know, when acting for creditors, it's something that I'm really passionate about. And I mean, you know, there's lawyers that like to play both sides. You know, I'm not one of those. Whenever you've at all suggested I run a preference, it's something I won't take on. But, you know, it's something I think that, you know, there needs to be a bit of a change or a shift, or something that's a little bit more balanced as to how those types of actions are being run, because it's of benefit to everybody if they work in a more harmonious way that actually benefits you know, recoveries under the appointment.
Yeah, it's one of those areas that's ripe for some sort of change legislatively. But in saying that, obviously, if I put my liquidator hat on, just to kind of give you some context, and I'm in a position where I've kind of got to wear both hats sometimes, right? A lot of the work that gets done in these, particularly in court-appointed matters, is done on the basis that we have requirements we have to discharge under the Corps Act, and there's not generally assets because it's taken so long to get to a point where the company's been wound up that they've been dissipated, or there's not a commercial ability to realise those from directors or other stakeholders, that preferences fund some of the costs of doing that work. And I'm not saying that that's the right reason for that. I'm just saying that there's a practical reality around that, and that's something that needs to be considered at a legislative level to try and get to a point where it may be fairer for people that have good credit practices, where they've been able to recoup funds because they've pursued the particular customer to make sure that they've got something, if not everything, paid. So it's one of those areas, as I said, it's ripe for change, and obviously, as you referred to, your submissions we'll come back to in a second, where you've put forward that on behalf of the Credit Forum and the Institute of Credit Management. So if we can just take a step back to the SBR piece, because I know that's something that is becoming more prevalent, and you can just see by the statistics there's 80 or 90 pretty much every month at the moment. So coming from a base of 5 or 6 in the first probably 6 months that the legislation was there and able to be used. There's a few things, particularly from the credit space, that I know are impacting your clients. While they're not necessarily a creditor, they have a registered security interest, and that's because they've dealt with them before or previously, and they have an account open still with them. It may not be used. It may not be substantially applied at the time that a small business restructure is in place. But there are circumstances where the small business restructuring practitioner isn't writing to those secured creditors to gauge whether there is a debt and at least alert them of the process. And I know that a number of trade credit insurers are taking a pretty hard line on that, where they're effectively taking coverage away from some very large companies in relation to dealing with that particular customer going forward. and they haven't been notified that the process has happened. So I think there's a lot of learning to be done still in that particular area. But what are your thoughts around that?
Yeah, the SBRs, I mean, it's really topical at the moment, and I think it sort of goes hand in glove with the other major topic at present, ATO, and the impact of the ATO defaults, and just generally the activity. But I think with respect to that, the SBRs and the impact on trade creditors, I guess what I'm seeing and what I'm hearing the most from all of my clients is that the businesses that are firstly engaging in the process don't actually understand the process in which they're engaging.
Yep.
It was only a couple of weeks ago I had a client call me where one of their customers had told them that an advisor had actually told them to incur a debt up to a certain value because it was a sweet spot to enter into an arrangement with the ATO to essentially go and rack up all of this credit, because this is when they'll deal with you with respect to the SBR, and the actual the debtor or my client's customer wasn't aware that by that appointment the impact that would have on the future trade of that business, and wasn't aware that it's very unlikely that my client's trade credit insurer wasn't going to then cover risk and allow them to engage. So I think the process generally has merit, and it's got things that could work really well for business. But I think the problem with what we're seeing practically is there are things being taken advantage of, or loopholes, I suppose, being utilised to, I guess, get outcomes that probably, in opposition to what was intended under the legislation in the first place. And where that's impacting, say, my client base is, as you mentioned, the insurers, will, nil limits because it's, an act of insolvency. You've got clients who, then having to deal with customers who are, not understanding the process, and, it's causing issues. Well, we're not able to trade with you. We're not wanting to trade with you.
Yep.
You've got this, this category of business that are under the misunderstanding that everything will be fine and we'll just roll it up to SBR and then just carry on as business as usual.
Yeah.
But the reality is a lot of creditors are unwilling to trade again with them, whether they're insured or not.
Yep.
So I guess the mix on all of that is causing problems. And then, as you alluded to, the actual notification of the various stakeholders, it probably isn't, being done as prudently as it should be.
Yeah, it's an interesting, I guess, mechanism, and it's in involvement, particularly over the last probably 12 or so months. It's effectively become the flavour of the month when it comes to restructuring, and it's something that, like you said, the spirit of the legislation and the practical realities of it effectively being used to wipe ATO debt is not. It doesn't gel with the reasons why it was implemented in the first place, which is effectively to help small business through the back end of the debt overhangs that have resulted from the COVID-19 pandemic. And actively marketing to these particular small businesses, saying, well, at the end of the day, you can keep trading as normal. Once the SBR goes through, it's just going to, you're going to have 20% of your tax debt that you've got to pay rather than 100% of it. They don't appreciate the underlying and the ongoing impacts to their business, whether it be trade credit because a particular supplier can't get trade credit insurance. Instead of having a $100,000 limit, perhaps they have a $20,000 limit. What does that do to the ongoing business or the viability of that business? Do they end up in a liquidation posted in any case because they can't get back to the same level of doing business because they don't have access to the same level of credit? There's those things that, education-wise, I think both the profession from my side of things and the clients from the directors confirming these appointments side of things, there's a ways to go in them understanding what the actual ramifications are.
Yeah, I think, and generally speaking, I think when you look at, small to medium business and, you think about, if you're a small mum and dad and you enter into business, whether it be like a small building business or plumbing or whatever, there's a real lack of awareness anyway with what it means to be a director of a company.
Absolutely.
and what all that. So I think, like, broadly speaking, there's an education piece. I mean, I can't tell you the number of times I've had a conversation, probably have one every 3 or 4 a day, where I might be speaking to, say, a director or a guarantor of a particular business transaction for one of my clients, and the individual doesn't understand their position as a director and their position as guarantor, or what all that means and how all that fits together, or or of the view, well, if the company's in liquidation, then I'm okay, and it doesn't, there's no impact on me. Like, there's such a lack of understanding, I think, in that legal entity and that interplay between liability. There's a whole education piece. I often think that before, being able to, be appointed a director, you should have to run, a particular course to understand your obligations as a director and what that means in running. It would just, I guess, not get rid of these issues, but it would certainly help people understand further, and would maybe allow businesses to, do business in a way that it's certainly, different to now.
Well, practically, particularly for a small business, the corporate veil is pierced in 10 different ways, because 9 times out of 10, if you've got a large supplier that's supplying you goods under credit, you're going to have a personal guarantee attached to it. And you would rightly so put that in place for your client if they're going to engage with someone going in a new business venture or new business dealings, because that's the prudent way to protect their interest. But you're right, like the mum and dads, the guarantors, the plumber rather than the guy from the advanced business world doesn't actually appreciate the required level of what they're putting up as collateral to start that business. Like builders, plumbers, those guys are great at what they do, but they also have to try and be a bookkeeper at 10 o'clock at night when they've got to get up at 6 for the new job the next day. And obviously things get left behind, and that's not what they're good at. They're good at fixing a tap or installing a bath. It's not, they shouldn't have to be in that position where they've got to try and wear 3 different hats, and when their day job is to build a nice bathroom. It's one of those things that you're right, the education piece from, if they want to be a director of a company, they should do a course to understand what their required obligations are and what happens when things go wrong. And it's not something that seems to be front of mind. It's just advisors setting up these structures and then allowing them to go off on their merry way and continue to do their day job and not understand the ramifications of it.
Yeah, certainly. I think there's a lot of that happens. Even, taking it a step further, I think there's a lot, and something I should have mentioned from the outset that I've been seeing a lot of recently is fraud.
Yeah.
And then, whether it be fraud or, individuals being put in situations that they're not completely aware of, that shadow director type approach, putting someone in, and there's actually someone else running the company, those types of things. You and I have been working our way through an enormous piece of potential. What are we going to call it? We won't call it fraud. We'll call it...
Well, it's very systematic in terms of its approach.
Yes.
And not for want of lack of trying, over 26 or 28 companies now, not one director has responded, not one director has provided a ROCAP, not one director has provided records. It's if they don't exist, and you can't get me onto the director ID side of things because that'll just go down another rabbit hole. The idea and the premise is great. The implementation of it hasn't been abysmal. That's not information that I can get access to, so I don't even know if Donald Duck's still running companies. But in this circumstance, it feels like that's happened, and it's been very well coordinated over a short period of time. And those things are obviously going to continue to be more prevalent or become uncovered simply because of where we sit in the economic cycle. And you're right, there's a lot of that happening at the moment. It'll be interesting to see how I go when I work through what I've discovered with ASIC to see what appetite there is to try and find the powers that be behind it.
Yeah, and I think, I mean, that's probably one of the larger scale, I guess, examples of that type of activity I've seen in a number of years. But even on a smaller scale, I mean, every other week, we're looking at matters where credit's been provided, goods or services have been supplied, and then looking to commence action or take some sort of recovery step, and you discover that the guarantor or the director don't exist, or perhaps it wasn't their signature that was on the documents, or these orders came from a representative of the entity and now we don't know who that representative was. It comes in its all small and big shapes and forms, but yeah, that's certainly that one we're talking about. That's probably the largest one I've seen in a while.
Well, unfortunately it's becoming more and more prevalent, as I said earlier. If we go back to the advocacy piece and the submissions that you were alluding to earlier, particularly on the PPS, and I know there's unfair contracts and things of that nature, you do a lot of heavy lifting, particularly for the Australian Credit Forum and the Australian Institute of Credit Management when it comes to those submissions. In your view, why are we spending so much time doing them? And as part of what has been put forward, have we seen or have we influenced any of the outcomes from a government perspective in terms of what's been implemented, and what's your thoughts about that whole process and what actually it achieves?
I suppose firstly, why are we doing them? I mean, as you've said there, so being a part of the Australian Credit Forum, something I've been involved in the last couple of years, why are we doing them? We're doing them because, what's the point of having a voice and wanting change if you don't actually do something about it?
Yeah.
And I know the members of the forum probably get sick of you and I badgering them every quarter and by email, every now and then.
Well, there seems to be a submission every 5 minutes at the moment, and it's got to be turned around in 2.
Yes, don't talk to me about the most recent. We'll forget they're due in a few days. But, why are we doing them? Well, I think, if there's a point of wanting change, or if there's a point of pushing a particular agenda, the only way you're going to do that is by making submissions to government. And probably the biggest process or submission process that I've been involved in was with respect to the insolvency inquiry last year. I mean, that in itself, those submissions, I think we had maybe 3 or 4 gatherings and putting those submissions together. There was a first set of submissions, and there were supplementary submissions put together following the inquiry. But to be involved in that process, and also to be involved whereby given a platform to talk about issues that impact, particularly in our way of things, creditors, and looking at that piece, but just also looking at more broadly insolvency and, giving submissions on whether the SBR or simplified liquidation process is an appropriate process, or, stuff around what happens upon an appointment and PPS, all those things that happen practically day in, day out. Being involved in that process and putting those submissions together was, something that I think was certainly worthy. And I know for the body of, people or members of the forum and representatives of that credit space that we were putting those submissions before, it was really important, because it was really important to highlight to government practices and things that were happening, or examples of things where perhaps legislation should be looked at to government. And, I recall being in the inquiry, running through just, again, I was being passionate about preference claims, that running through some of the case examples that I had as to, where action had been commenced on preferences, as small as like a couple of $1,000, things like that. And just, the members that were sitting there and listening to that inquiry were startled, were shocked, because I think there's quite like a disconnect between what happens in real world as to then what happens in, if you're sitting there in government, to understand what actually goes on. So I guess that's why we do it, because if we don't bring those issues to the forefront, we'll never see change. Now, have we seen too much flow from there? Not really, not yet. I mean, I know there was obviously the outcomes and things, and there's things that have been looked at moving forward with respect to particularly that simplified liquidation piece with respect to preferences, and there were other things that were looked at. But have we seen it flow through yet? Not entirely, but it's there, and it's there for, I guess, the processing, and it'll be depending on whether the government takes up those steps.
It was really a rhetorical question because I knew the answer from my point of view and yours, but it's more for the listeners out there. It's actually quite a demanding process because, like you said, there was 3 or 4 rounds of getting the forum together and the Institute of Credit Management and working through each of the things that they'd asked for feedback on, and obviously having yourself there sitting in front of the panel, the committee, and working through the practical examples that you alluded to from the preference piece, but also just the impacts. There was a very well-known banker that was on just before you, and the questions that were being asked from the parliamentary committee were actually very poignant, and he didn't have very many answers that they seemed to think were appropriate. But when you were up there, you're in a position where they took a real interest, particularly in that preference piece, and they asked you for additional submissions post it. And I know that there was reference to those submissions in the actual report that got handed down. So there is merit in doing it, and it felt like that the committee in that circumstance actually listened to the feedback and put a fair bit of weight around it, and that obviously came through in their report. Like you said, it depends on what the government's overarching position is, I think, politically, as well as their appetite for change and how that may or may not be implemented. That's still to be seen. But yeah, you're right that as much as it's an impost on time, if we don't use the opportunity and the platform to put forward the voice, particularly of people like the forum, there isn't going to be the change that's required. And at the end of the day, having that opportunity and using it's going to be more beneficial than not.
Yeah, definitely. And I mean, it's the whole thing. If you've got an issue and you're not escalating it, you're not raising it, then how do you expect anything ever to be done?
Yeah.
So I think, it remains to be seen. I mean, I think over the years of being a part of the forum, we've written many submissions. That was the first time we were ever put in front of government. But again, it's the reason why you do that is to be there in front of whoever's the stakeholder that needs to be having this brought to their attention.
Yeah.
So, we'll see what comes through. I mean, I did just see there was a consultation for payment times reporting that's come down, I think, yesterday or something. Another one that's due.
Well, you got the bankruptcy stuff too, which we're going to look at the next few days.
Yes. So, but all really, really important matters, I think, that need to be being looked at. And we're lucky, I guess, that we live in a democratic society where we can do these things,
that
and we can have the ability to put submissions towards government and actually have an opinion on whether it's heard or not, for various bodies. So, I mean, that in itself, I think, is something to be mindful and grateful for.
Absolutely. I guess rounding things off, if you were going to give any practical advice to, let's just say, a trade creditor that comes to you and says, hey, I've got this trade credit agreement, can you have a review of it? Or I've had this company go into liquidation, how do I go about making sure I'm in the best position to try and get a return? I know we've kind of touched on a lot of things in this, but if you could put it in 3 points, what would they be?
Oh, 3 points. Probably picking up, I can talk for days.
Yes.
Okay, so someone comes to you, you've got an issue, what are the best things you can do? First and foremost, it's about preparing for the worst. So what's your risk mitigation strategy? What does that look like?
Yep.
And I would say your risk mitigation strategy is combined with your contractual framework in which you engage.
Yep.
The way in which you protect your position by way of security.
Yes.
Whether that be PPS, whether that be, any other type of general security that you take. How can you and are you able to put yourself into a position of being a secured creditor in the event of?
Yep.
So there's that risk mitigation strategy. It's it's your guarantor piece. It's even just the simple, straightforward understanding who you're dealing with. So that risk mitigation strategy would be first and foremost. What's the right thing for your business? Because what's right for your business isn't always going to be right, for the next business, because it's going to have that veil of commerciality.
Yes, absolutely.
So that's sort of my number one first point. So have that strategy in place. Second thing would be, get yourself a good lawyer. And I don't say that lightly. We joke all we like, but not all lawyers are created equally.
No, absolutely.
But it's being able to have someone to call upon in circumstances or in times where you do need and get some quick advice. And it doesn't mean you need to engage them completely, but have someone available to bounce things around. So in the event that you might be caught up in litigation, things have been done in a certain way that doesn't cause you problems.
Yep.
That can often be something that I see in practice where someone's failed to just check in that they're doing the right thing, and then they've got problems elsewhere. So it's risk mitigation strategy. It's like generally having like a trusted advisor, whether it be a lawyer, whether it be someone like yourself.
Yep.
Have a trusted advisor in place. And then I guess the third tip would be proactive. Whether in anything, always be proactive, putting your head in the sand, whatever the scenario, whether it's someone owes you some money, whether it's been hit with a preference demand, whether it's, you're being served with proceedings, or whether it's you've had some claims around, how your contract looks. Being proactive, I think, would be the third tip.
Absolutely.
So it's risk mitigation, have a trusted advisor, and be proactive. There you go, I did it in 3.
That's what I asked for, and I think you did a very good job.
With subheadings, of course.
Look, thank you so much for your time today, Anna. Obviously, a pleasure as always. Looking forward to seeing where we get to in the next 6 or 12 months, and obviously continuing to fly the flag for your trade creditor clients and obviously all the other ones that you're dealing with too. Pleasure as always.
Thank you for having me.
Thanks for tuning in to Cathro Partners, The Cut. We hope you've enjoyed today's episode. For more insights, please visit our website, cathropartners.com.au, or find us on LinkedIn.